May it please this honorable court, my name is Yasmin Saraya from YES Associates.
YES Associate?
Yes,
Wow, okay.
Yasmin Emma Sara.
Because you are acting on behalf of government, right?
No.
Oh, okay, betul lah.
20%.
20, okay.
I'm the senior counsel appearing on behalf of the plaintiff, and accompanying me today are my co-counsels, Ms. Sarah Felicia and Ms. Sufir. Young Arif, there are two grounds we would like to submit in this instant case. Ms. Sarah Felicia and I will be dealing with the first ground, meanwhile Ms. Sufir will be dealing with the second ground. For the first ground, we reason that the government's decision to evict the squatters is immoral. For the second ground, is the right to freedom of the squatters of Taman and Joy being abused by the City Council of Mamaland State? Would Young Arif find a brief summary of the facts of the instant case helpful?
Okay, no need. Proceed with your submission.
Alright, if Young Arif has no further questions on the case, I shall proceed to my submissions. Young Arif, the first ground we'd like to submit revolves around the issue of whether the actions of the government is morally justified. Before diving in further into the case, I would like to briefly define the definition of morality. Although there is no single definition of morality, however, it can be generally understood as a guiding principle of what is right and what is wrong, as well as what is acceptable and unacceptable by the society. To begin with, there is a fine line between morality and law. It is said that morality forms the basis of law. Therefore, how can we determine whether the law is morally right or morally wrong? According to the utilitarianism standard of morality, an act is moral if it is useful in bringing about a desirable good, and according to Jeremy Bentham, actions are approved when they bring happiness and pleasure, and disapproved when they bring unhappiness or pain. So based on Jeremy Bentham's view, the action of the government in evicting Taman and Joy squatters from their settlement is considered to be immoral because it causes pain and unhappiness to the squatters. This can be clearly seen as the squatters, especially the children, were crying at the sight of their precious books and uniforms being destroyed. Several women were fainting due to the shock, and most of all, as some squatters reacted aggressively to this, they were sprayed with painful tear gas and water cannons. On top of that, in 2007, the Special Rapporteur on Adequate Housing presented to the Human Rights Council a set of basic principles and guidelines on development-based evictions and displacement. In Guideline Number 6, Clause A, forced evictions as defined under international human rights law must be prohibited in all circumstances, regardless of ownership or tenure status of those affected. Victims of forced eviction must receive adequate compensation, reparation, and access to housing or productive land as appropriate. In this case, the squatters of Taman and Joy were victims to forced evictions, even though it is stated in the international human rights law that it shall be prohibited regardless of the tenure status of those affected, which is the victims having the status of being squatters. Furthermore, Young Arif, according to the Human Rights Committee in the International Covenant on Civil and Political Rights, they held that not giving due consideration to the consequences of the eviction from the settlement, such as the risk of becoming homeless, the state party would interfere arbitrarily with the homes of people living in the settlement. Consequently, the state was under the obligation to refrain from evicting the community until satisfactory housing was available. I repeat, consequently, the state was under the obligation to refrain from evicting the community until satisfactory housing was available. In this case, the City Council of Mamaland did not take into consideration the consequences of evicting the squatters from their settlement, such as causing the demolition of their personal property, that is their books and uniform, as well as the state of them becoming homeless. Furthermore, since the squatters appealed for a 3-month extension to enable them to find a new place to live, the City Council is actually obligated to refrain from evicting these squatters until they could find a new place to live. Now, I'd like to refer to one of the pioneer cases on squatters' rights, which is the case of Civic against Perak State Government in 1981, which said squatters have no rights either in law or in equity. A court of equity will never assist squatters to resist an order of possession illegally acquired, and it will never intervene in aid of wrongdoers. This clearly shows that the law does not protect squatters whatsoever, even though it includes vulnerable groups such as children, the elderly, and women. In addition to that, statutory laws have been allegedly misused and abused to evict squatters. A case point is the Essential Clearance of Squatters Regulations 1969, which is a law that was enacted during the emergency to relocate by force those alleged to have links with militant communists, has been used to evict squatters in, for instance, squatters in Kampung Bajaya. In the incident of 1969, the government had reasonable cause to evict the squatters. However, in this case, the City Council of Mamalan State had evicted the squatters without reasonable cause other than them living in an uninhabited land. In conclusion, based on the opinion of the jurists, under the law and case law that we have provided, our grounds are aligned with the principles of morality that we have set. Therefore, we implore Yang Arif to consider our stance on this issue. I thank the court for its time, and that concludes my submission, and I shall yield the floor to my co-counsel.
How you use the case of Siddiq government of Perak to support your case, to support the client? How do you, because in that case it says that the squatters do not have right.
Yes, and I use this case to showcase that because the court said that the squatters have no rights, therefore it clearly shows that the law does not protect squatters' rights whatsoever, even though they are among the vulnerable groups.
Okay. Thank you, counsel.
If it pleases the court, Yang Arif, as already stated, my name is Sarah Felicia and I appear as junior counsel for the plaintiff. If it pleases Yang Arif, I will now proceed with my submission.
Okay, proceed.
Yang Arif, as noted by my senior counsel, I would like to discuss further regarding our first ground, whereby we reason that the actions of City Council of Mamalan State towards the squatters of Taman and Joy are immoral. According to Black's Law Dictionary, morality can be defined as pertaining or relating to the conscience or moral sense or to the general principles of right conduct. It raises a belief that is independent of strict or logical proof. There are various sources of morality. However, I would like to emphasize religion as a source of morality. According to the Al-Quran in Surah An-Nahl, ayat 125, invite to the way of your Lord with wisdom and good instruction, and argue with them in a way that is best. Indeed, your Lord is most knowing of who has strayed from his way, and he is most knowing of who is rightly guided. Relating to this case, this means that we should approach the poor and needy in a gentle manner with kindness in our hearts. On the contrary, it is evident that the City Council of Mamalan State has acted in a way that is totally immoral towards the squatters of Taman and Joy by conducting the eviction, using aggression and hostility when the use of water cannons and tear gas was utilized. It is also crucial to take into account the consequences of the City Council's actions. Due to the usage of the water cannons and tear gas, the squatters suffered from health problems. Referring to the United Nations Basic Principles on the Use of Force and Firearms by Law Enforcement Officials, BPUF, it is the key international instrument that deals with police use of force, and it is an international best practice. According to BPUF, law enforcement officials shall exercise restraint in such use and act in proportion to the seriousness of the offense and the legitimate objective to be achieved, and minimize damage and injury. In the dispersal of unlawful but non-violent assemblies, enforcement officials shall avoid the use of force, or where that is not practicable, shall restrict such force to the minimum extent necessary. Yang Arif, it is unacceptable that by exercising the right to challenge the authorities, the squatters of Taman and Joy have become victims of violence. The government should stop patting itself on the back and promptly investigate why unnecessary force was used and punish those responsible. Whether the government likes it or not, there will be future demonstrations, and the government will need to do a better job to ensure security and respect people's rights. Yang Arif, I would like to submit my third argument, which utilizes the harm principle. According to English philosopher John Stuart Mill, people should be free to act as they wish as long as their actions do not cause harm to others. According to Mill, disapproval or social dislike of an action, such as being offended by what someone says or wears, is not enough to invoke the harm principle and limit personal freedom. Relating to this case, I would like to argue that the harm principle is very much relevant to this case, as the squatters incur no harm to others. Yes, a squatter has no legal entitlement to the property and is considered an unlawful occupant. However, there is no occurrence that explicitly implies that the squatters were causing harm to the City Council of Mamalan State. The squatters are victims of their circumstances and do not live on the streets by choice. I would also like to insert a standard of morality, which is critical morality. in my argument here, which requires us to reassess their interpretation of morality by a biased party and reorient our day-to-day judgments. We need to evaluate the situation because there is more than what meets the eye. Young Arif, it is reasonable to state that morality forms the basis of law. We need the law to identify the morally right thing to do. I would like to introduce the Destitute Persons Act 1977 into today's hearing, which has been at the core of federal state strategies for homelessness for 40 years.
Destitute what?
Destitute Persons Act 1977.
Malaysian law.
Yes. By this law, government officers have the power to conduct raids on destitute persons and detain them in welfare homes. However, in this case, the City Council of Mamaland State did not even provide the squatters welfare homes to use as shelter. Instead, completely ignored their plea for a 3-month extension to find housing. Over the past century, the criminalization of homelessness have proven to be ineffective in reducing homelessness as they do not effectively address the social and economic root causes, which include a lack of affordable housing and inadequate income. Is the government doing anything to reduce homelessness? Yes, driving them away from Taman and Joy. Is the government fixing the issue of homelessness? Absolutely not. Such measures deprive people in need of fundamental liberties. Also, they do not demonstrably improve social and economic stability in their lives. Therefore, the failure of operations and institutions under the Destitute Persons Act lies in the overall system's punitive approach. Based on the statements I have provided through religious scripture and legislation, the government's actions are inexcusable on the grounds of morality. Morality should be mandated by law for the purpose of upholding justice in Malaysia. Therefore, I humbly request Young Arif to consider our justifications on this case.
Okay, thank you, Council.
May I please the court? My name is Siti Rozaima binti Abulijan. I appear as the junior counsel for this proceeding on behalf of the plaintiffs, squatters of Taman and Joy. If it pleases Young Arif, I will now proceed with my submission. As my senior counsel has mentioned, Ms. Yasmin Soraya and my fellow junior counsel, Ms. Sarah Felicia have discussed our first ground, which is morality. Therefore, now I will discuss our second ground, which is about the cruelty committed by the defendant who has deprived our plaintiff of their freedom. I will address the issue, which is whether the right to freedom of the squatters of Taman and Joy was being abused by the city councils of Mamaland State. But before that, let me explain and define the meaning of freedom in human life. According to Martin Golding, freedom is the right, power, ability to decide for oneself what to do and how to live according to one's interest, desire, taste, determination, or thought of the mind to realize one's ends. In addition, Immanuel Kant defined the right to freedom as independent from being constrained by another choice, insofar it can coexist with the freedom of every other in accordance with a universal law. Freedom is important because its infringement is detrimental to our well-being and inconsistent with our nature. Therefore, freedom must be protected in order to safeguard the welfare of our party. Freedom can be protected with the concept of human rights. Human rights are rights inherent to all human beings, regardless of race, sex, nationality, ethnicity, language, religion, or any other status. Human rights include the right to life and liberty, freedom from slavery and torture, freedom of opinion and expression, the right to work and education, and many more. Young Arif, as I previously stated, our client freedom has been violated by the action of the City Council of Mamaland State. This assertion is supported by my emphasis on the idea of human rights, which state that human rights include the right to life and liberty, freedom from torture, freedom of opinion and expression, as well as the right to work and education. Therefore, I will go over each of the defendant acts that have limited this kind of freedom. To begin with, the defendant conduct against our plaintiff doesn't seem to have taken into consideration the fact that Hari Raya was only a week away that day and that 70% of the squatters at Taman and Joy are Muslim. According to Article 11, Clause 1 of Malaysia Federal Constitution guarantees the right of every person to profess and practice his or her religion and subject to certain restrictions to propagate it. Nonetheless, the defendant forced demolition of the house prevented the Taman and Joy Muslim squatters from easily engaging in their religious practice. Given that the home they have lived in has been demolished and they have nowhere to reside, where can the Muslim squatters celebrate Hari Raya and pray with their loved one? Yang Arif, this kind of action essentially means that our plenty freedom to exercise their religion will be inevitably restricted. Other than that, the defendant has sprayed water cannon and tear gas to the squatters of Taman Enjoy without considering the long-term effect on our plaintiff health. According to global health expert, the water cannon can cause individual development of hypothermia, while tear gas can cause severe eye irritation and even cause death. This cruel action by the defendant seems to have restricted the freedom to live longer and peacefully for our plaintiff because it can lead to serious health problems and even death. According to the English philosopher John Locke, he stated that no one ought to harm another in life, health and liberty of possession. Therefore, if referring to the Penal Code section 324, the enforcement 324.
Okay.
The enforcement officers shall be punished as they had violently hurt the squatters using harmful weapons that can cause irritation to the squatters. Furthermore, I would like to insert a scholar's view. In accordance of this opinion, the enforcement officers can be punished as everyone is equal before the law. In addition, the enforcement officers don't have any right from prohibiting the squatters to express their frustration towards the eviction process because they don't use any harmful or dangerous weapon when they're forming a human barricade with women and children that were placed at the front line. They were just holding banners and chanting a loud protest against Jumbo and his team without using any dangerous weapon. It is clear that in the Article 10, Clause 1, sub B of Federal Constitution, where all citizens has the right to assemble peaceably and without arms. Therefore, the protest can be considered legal as they're not harming any parties. Lastly, according to the Children Act 2001, Act 611, children must be protected from discrimination. They have the right to life, survival, and development. Respect the view of children and take into account the best interests of children, which cannot be neglected by any person. However, the action taken by the defendant is contrary to this act because the defendant action was very cruel to the children as they ignored several children who were seen crying and sobbing as their textbooks and school uniform were crushed by the heavy machineries. This clearly shows that the action of defendant do not care about the best interests of the children at Taman Enjoy, whereas these children should be given more care and attention because they are less able to live comfortably compared to other children out there who live comfortably from childhood and are overflowing with wealth. Young Arif, how will these children continue their education if all their school supplies have been destroyed? Yes, maybe the textbook can be bought again, but what about the knowledge and hard work that these children has been poured into the damaged book? As a result, the defendant has also restricted the freedom from these children to continue the education because these children will not be able to continue the education without school supplies and may be traumatized by what happened in front of their eyes. In conclusion, the issue of squatters cannot be considered as isolated matter, as observation and study have identified numerous social issues and problems to derive from it. Therefore, the City Council of Mamaland have no right to evict the squatter settlement without being considered with several things before evicting the squatters, as it can lead to several consequences to them. For instance, squatters who are evicted may lose their shelter and become homeless, as well as facing difficulties in finding employment, accessing education and healthcare, and with all of these consequences making the squatters of Taman Enjoy have the right to defend themselves and remain in their property. That's all from me.
Thank you, Council. Okay, we move on to the defendants.
Assalamualaikum and a very good day to Your Honor. Shall I start?
Okay, you can start.
Young Arif, if it pleases this honorable God, I am Ms. Nur Farishadia, and I'm the City Council representing City Council of Mamaland, which hereinafter will be referred as the respondent. Along with me, Ms. Nur Khadijah and Ms. Jasmina will be the junior counsels for the respondent. Young Arif,
I have two grounds of plea to present in my submission today. For the first ground of plea is that the action of the squatters to oppose or to resist the eviction was a violation of the principles of freedom. And the second ground is that the City Council action in response to the aggressiveness of the squatters is not immoral. Yang Arif, from my part, I will be focusing on the first submission is that whether the action of the squatters to protest is not considered an act of freedom. As we know so far, the plaintiff has stated that the squatters at the Taman Enjoy have the right of freedom and that the defendant had abused the right of freedom. My Lordship, now I want to ask, what is the real meaning behind the word freedom? I will refer to the definition of freedom by Martin Golding that was stated by Ms. Siti Rozaima, but I will highlight freedom is the right, power, ability to decide for oneself. In this case, I believe that the squatters have no rights, no power to decide that they can live on the land. Hence, they do not have the freedom to protest their rights of the land. Now, there are two types of freedom based on what Esai Berlin has argued, which are negative freedom and positive freedom. In this case, we can classify it as negative freedom as the centers of freedom from interference, obstacles, barriers, and constraints. My Lordship, do the squatters think that they do not have, that there is no limitation of freedom? Well, freedom enjoyed by individuals is not absolute, because as a member of the society, an individual's right must be harmonized with the duties towards the society. Thus, law is established to limit someone's freedom according to Ros Kapang. Law protects various interests in society. To strengthen my argument, according to Article 9, Clause 2 of the Federal Constitution, stated that the freedom is subject to restriction that can be made by the government for the purpose of maintaining public health and public order, which means that even rights of freedom in the Federal Constitution has its own limitation. Yang Arif. Now, I would like to give some definition of the squatters. According to Oxford Dictionary, a squatter is a person who unlawfully occupies an uninhabited building or unused land. From a legal perspective, a squatter is someone who occupies a piece of land or property without legal right or legal title to do so. Furthermore, Justice Richard Malanjum explains squatters in this way. What is squatter? He is the one without any color of right enters an occupied house or land, intending to stay there as long as he can. He may seek to justify or excuse his conduct. He may say that he was homeless and that this house or land was standing empty, doing nothing. But this plea is no avail in law. This is according to the case Cha Swanyo versus Moy and others, 1992, 2 MLJ 666.
Come again, the case name?
Cha Swanyo versus Moy and others, 1992, 2 MLJ 666.
Okay, proceed.
Okay. Yang Arif, Malaysia has been struggling with the squatter issue in the face of increasing urbanization since the 1980s. Most issues regarding eviction of squatters can be referred to the National Land Code 1965. According to Section 48 National Land Code 1965, no adverse possession against the state where no title to state land shall be acquired by possession, unlawful occupation, or occupation under any license for any period whatsoever, and Section 314 of the National Land Code 1961, and further supported by the Federal Court decision in Sidik bin Haji Muhammad and 461 others versus the government of the State Perak and others, 1982, 1 MLJ 313, firmly established that the squatters have no legal right to the land they occupy, regardless of how long they occupy the land, regardless of how long they have been unlawfully occupying the land, and practically means that the owner can take appropriate action to evict the squatters at any time after any period delay. Yang Arif, I believe that the Article 1, Clause B of the Federal Constitution, where all citizens have the right to assemble peacefully without arms, should be read together with Peaceful Assembly Act 2012. That was drafted 4 months after the Bersih 2.0 rally that was held on July 2011. The Bersih rally enlightened the importance of any assembly to fulfill some requirements before being held. This is being said because the government authority have no power to prohibit assembly, as it is a right of freedom. According to Section 2, Subsection B of the Peaceful Assembly Act 2012, the object of this act are to ensure the exercise of the right to organize assemblies or to participate in assemblies, peacefully and without arms, is subject only to restriction and deemed necessary or expedient in democratic society in the interest of the security of the Federation or any part thereof or public order, including the protection of rights and freedoms of other persons. In this case, The squatters' protests violate various sections in the Peaceful Assembly Act 2012, such as Section 6, Subsection 2F, the responsible of the organizers to cooperate with public authorities, and Section 7, Subsection A2, where the participants shall be refrained from behaving offensively and abusively towards any person. The protest of the squatter clearly violates all the sections that was stated as in the fact of the case, as the squatter refused to back off. Even the defendant appealed for the squatters to give up their protest and to cooperate with the defendant, and the squatters began to react aggressively towards the defendant. Young Arif, we respectfully disagree with the appellant's submission that stated that the defendant did not give any consideration and accused that the defendant violates the Article 11 of the Federal Constitution, where they accused that the defendant did not think of the consequences of the eviction and restrict the squatters to practice their religion with an excuse that Hari Raya celebration was at that time of the incident was only a week away. The defendant empathized the squatters and even gave 6-month eviction notice, which 1.5 years to prepare for the eviction. My lord, my lordship, the defendant was considerate enough to even give that much time to the squatters, even though the land was not theirs, and the defendant have the legal right to evict the squatters at any time after any period delay. Furthermore, the appellant's submission also accused that the City Council committed crime that related to the Section 324 of the Penal Code that mentioned. Sorry, can I repeat that? Furthermore, the appellant's submission also accused that the City Council committed a crime that related to the Section 324 of the Penal Code that mentioned voluntarily causing hurt by dangerous weapon or means. We believe that the City Council enforcement scene actions were not voluntary, as it was a response to the aggressiveness of the squatters. In addition, this section can be applied as the City Council Enforcement Unit has the right to use water cannon and tear gas properly as a way to disperse an assembly based on the Federal Unit Reserve stated in Human Rights Commission of Malaysia that will be furthermore explained by Ms. Khadijah. Hence, the action of the squatters to protest was not an act of freedom. Not only it abused the rights of freedom, the action was a way for them to show objection to the law of the land, where they have no legal rights to begin with. The squatters were taking advantage of the land where they paid nothing to live on the land, not like the rest of the citizens in Malaysia. Not only that, Young Arif, they had also ignored the 6-month eviction notice that had been informed by the defendant. This action can be related to the famous Latin legal phrase, ignorantia facti extusat, ignorantia juris non extusat, which means ignorance of fact is an excuse, but ignorance of the law is not an excuse. And that to conclude my submission, Young Arif. Thank you, Young Arif, for listening to my submission. I do hope that you, Young Arif, would dismiss this case of defendant. I thank this court for its time and indulgence. My junior counsel, Ms. Khadijah, will continue with the second submission. Thank you so much.
Thank you, Counsellor.
Young Arif, as the senior counsel introduced me, I am Nur Khadijah, the junior counsel, and I will proceed my submission with the issue of whether the government action by spraying the squatters with water cannons and tear gas is considered immoral. Just now, the plaintiff has stated that the government decision of eviction is immoral. However, we need to ask ourselves, does a law need to be moral in order to be valid? I argue that law does not need to be moral to be considered valid. To support my contention, I will explain more about morality. Morality is a set of social principles that determine the right and wrong acts of a person. According to Hans Kelsen, if somebody disapproves of the commended behavior or approves the opposite, he is said to have behaved immorally and must himself be disapproved. There are several schools of thought, which are positivists, naturalists, and sociologists. Regarding this case, I prefer to use a positivist view as it believes in separability thesis, which proposes that law does not depend on its conformity with moral principles. John Austin, who is an English legal theorist, states that law is legally valid in society only if it is commanded by the sovereign body of a particular state. Austin, in the province of jurisprudence, states that the existence of law is one thing, its merit or demerit is another. In corresponding, Article 3 of the Police Act 1967 stated that the police may stop an assembly if no license has been issued for the assembly or if the license was subsequently cancelled or if the assembly contravenes any of the conditions of the license issued. I will relate this act with a case which is Nik Nur Hafizi bin Nik Ibrahim and Ors versus Public Prosecutor 2013 1 MLJ 831. The appellants who were
Nik Nur Hafizi against public prosecutor. Come again. The name of the case. Nik Nur Hafizi.
Nik Nur Hafizi bin Nik Ibrahim and Ors.
Others. Okay,
And
again.
others, versus Public Prosecutor.
Okay, can you proceed?
The appellants, who were undergraduates of various universities, were found guilty by the magistrates court of being in unlawful assembly held on the grounds of the National Mosque in Kuala Lumpur to protest against the Internal Security Act 1960. They were each fined 3,900 ringgit in default 3 months jail for the offence under Section 27, subsection 5 of the Police Act 1967. The Assembly did not have a police permit under Section 27, subsection 2 of the Act. Young Arif, now I would like to relate the law present with the case between the City Council of Mamaland and the squatters. I insist that the government action of spraying water cannon and tear gas towards the squatters is not considered immoral. As according to the Human Rights Commission of Malaysia, if there is a resistance to the order to disperse, then force by the Federal Reserve Unit will be used in a specific order by discharge the tear gas. The tear gas is fired only on the instruction of the commanding officer. The direction in which the guns are discharged will depend on the wind direction. The tear gas should always be fired over the heads of the crowd and at an angle of 70 degrees and never directly at the crowd.
So there is a measurement for the firing of tear gas in that Human Rights Commission Act.
Yes.
Okay, proceed.
So I can guarantee that there will be no person harmed in while spraying the tear gas. The FRU may be assisted by the water cannon unit. The water used in the water cannon may be plain water or water mixed with chemicals. Moreover, I argue that the squatters' action of protesting against the City Council by forming a human barricade with women and children at the front line is moral. Why do the squatters put women and children at the front line? Because according to the Article 17, Clause 1 of the Child Act 2001, Section 1,
No, I mean Section 17 of Child Act.
Section 17 of Child Act 2001, a child in need of care or protection if the child has been or there is a substantial risk that the child will be physically or emotionally injured by his parent or guardian. Why don't the squatters put men at the front line instead of women and children? Also, we can see that the parents themselves put their children at the front line without concern for their children's safety. Young Arif, to conclude my contention, I would like to highlight that the City Council action cannot be considered as immoral. It is because the City Council, including the government enforcement authorities such as police, followed the regulation and had the right to use such force as the squatters began to react aggressively towards them. Thank you, Young Arif, for listening to my submission. Now, the next Junior Council, Ms. Jasmina, will continue with the next submission.
Okay, proceed, Council. Thank you very much.
Assalamualaikum and a very good day, Young Arif. Young Arif, as the Senior Council has just introduced me now, I am Jasmina binti Khairul Amin and I appear as the second Junior Council representing City Council of Mamaland from the defendant's side. If it pleases Young Arif, I will now proceed with my submission. As for today, Young Arif, I will be discussing the issue regarding whether the act of evicting the squatters by the City Council of Mamaland is considered moral. As the Junior Council has just explained, morality is a set of social principles that determine the right and wrong acts of a person. Additionally, the word moral can also mean ethical, noble, righteous, and virtuous. Moral principles can also define what is acceptable and what is unacceptable in society. However, when a person performs an act, his intention is taken into consideration in morality. Hence, morality is considered an essential for human relationship at all walks and levels of life. In this case, the City Council of Mamaland has the right to evict the squatters as referred to Section 7, Sub 2 of the Specific Relief Act 1950, which extinguishes a landlord's right to recover possession of his property through the remedy of self-help. Instead, the landlord is obliged to recover
possession of the property via proceedings in court. The eviction notice was already informed to be carried out to the squatters of Taman Enjoy. Hence, it was moral for the City Council of Mamaland to evict them when they were resisting the eviction proceeding. This is supported in the case of Idak bin Haji Muhammad and 461 others versus the government of the state of Perak and others, 1982, 1 Malaysian Law Journal 313, the city case, which in particular, the federal court held that squatters have no right either in law or in equity that a court of equity will never assist squatters to resist an order of possession illegally acquired. Furthermore, under Section 340 of the National Land Code states that occupied land without any license or consent of the state authority or state government, the said occupation was a trespass on the land in violation of the plaintiff's indefeasible lease interest in the land. This is supported as seen in the case by Hajmi bin Din and others versus Elite Agriculture Sdn Bhd.
Come again, Haji Din.
Hajmi bin Din and others versus Elite Agriculture Sdn Bhd. 2022, 5 Malaysian Law Journal 363.
What year?
Sorry?
What year the case was decided?
2022.
2022. Okay, it's a new case, okay? Can you provide the brief of the facts of the case? Do you have the facts of the case? Brief facts only. No. Okay, proceed.
Moreover, in the case of Sangka bin Chuka and Anur versus Pentadbir Tanah Daerah Mersing, Johor and others, 2016, 8 Malaysian Law Journal 298, the first respondent had issued a notice, which the notice was affixed to a tree in Pantai Burong located within 25,295 hectare Johor Endau Rompin National Park that required trespassers to demolish any structures they had built or vegetation they had cultivated and to vacate the area within 24 hours. The notice said that if they failed to do so as directed, penal sanctions would be taken against them under Section 425 of the National Land Code. And although the notice was addressed to whom it may concern, the applicants contended that it was directed at the Jakun community of the Orang Asli in Kampung Peta. This was because 4 months before the notice was issued at the third respondent urging, the latter had written to the second applicant requesting that the Jakun of Kampung Peta refrain from clearing, cultivating and carrying out other activities in and around Pantai Burong and to vacate the area. According to Section 425 of the National Land Code, it states that whoever occupies on any state land, reserved land or mining land without lawful authority shall be guilty of an offence. Additionally, according to Section 3, Sub 1 of the Land Acquisition Act 1960 in Malaysia, the state authority has the power to acquire any land which is needed for any public purpose, such as for the construction of public railways, public highways, and more. To apply in this case, squatters of Taman Enjoy are guilty as they had committed an offence to the law as they refused to evict the land after the law had said so, according to Section 425 of the National Land Code, which states that whoever occupies on any state land, reserved land, or mining land without lawful authority shall be guilty of an offence. Furthermore, since there was no consent from the City Council of Mamaland for the squatters of Taman Enjoy to further stay at the land since the eviction process was told to be carried out, and most importantly, even when the 6 months eviction notice had already expired. The squatters are considered trespassing on the land of the government after the eviction notice had been issued, as had been clearly stated according to Section 340 of the National Land Code, which is that the occupied land without any license or consent of the state authority or state government, the said occupation was a trespass on the land in violation of the plaintiff's indefeasible lease interest in the land. Lastly, Section 3 Sub 1 of the Land Acquisition Act 1960 shows that Section 3 Sub 1 of the Land Acquisition Act 1960 shows that the City Council shall be entitled to the exclusive use and enjoyment of their land by evicting the squatters of Taman Enjoy, which is entirely moral to do so. In addition, relating to the harm principle, which has been stated by junior counsel from the plaintiff's side about it being very much relevant to this case, as the squatters incur no harm to others. they emphasize on how a squatter has no legal entitlement to the property and is considered an unlawful occupant. However, there is no occurrence that explicitly implies that the squatters were causing harm to the City Council of Mamaland State. As we can see in this case, since the eviction notice was already issued and had been carried out for 6 months, which is equivalent to a half year's time, the squatters of Taman Enjoy still refused to evict the land despite the time given. To add, even when the eviction notice had already expired, the squatters were already prepared to resist the eviction proceeding by the authorities, which shows that they are causing extreme harm by forming a barricade with women and children at the front line and protesting against Jambu and his team. To further add, even when Jambu appealed to the squatters to give up their protests in order to cooperate with him without using and showing any threat, the squatters still refused to back off, which indeed is a harmful act since they were resisting and expressing their anger to the authorities even when the squatters clearly have no legal entitlement to the property and is considered an unlawful occupant on the land. All in all, the squatters' actions can't be done freely as it causes harm to the City Council of Mamaland. Plus, regarding the City Council's act of spraying the squatters with water cannons and tear gas, it is considered moral and unharmful, as has been already stated by the Junior Counsel from my team. According to the Human Rights Commission of Malaysia, if there is a resistance to the order to disperse, then force by the Federal Reserve Unit will be used in a specific order by discharge of the tear gas. According to the Public Order Reserve Unit, PORU, and the Federal Reserve Unit, FRU, each has its own standard operating procedure for crowd dispersal, which in this case is the squatters. For the PORU, crowd dispersal begins with a warning to disperse. If the crowd disperses, the crowd dispersal action ends there. If there is a resistance to the order to disperse, then force will be used in a specific order. In this case, the City Council must use their forces against the squatters, since the squatters were already prepared to resist the eviction proceeding. And to add, the tear gas is fired only on the instruction of the commanding officer and should always be fired over the heads of the crowd at an angle of 70 degrees and never directly at the crowd. Hence, it won't harm the squatters in any way physically, as the forces are being used in the most ethical way with purpose. On top of that, under Section 27B of the Police Act, the police are allowed to use force to disperse assemblies when three conditions are satisfied. A, there must be an order to disperse. B, there must be a refusal to disperse. And C, only if there is resistance to an order to disperse should force be used and to overcome the resistance. To apply in this case, the City Council acts as a government enforcement authority, which gives the right to them to use forces against the squatters' assemblies to ease the eviction process, as the squatters have already fulfilled the three conditions stated just now. Therefore, the City Council's action does not come in any form of harm whatsoever to the squatters. All in all, the actions of the City Council of Mamaland State towards the squatters are considered moral, and the right to freedom for squatters of Taman Enjoy were not being abused by the City Council of Mamaland, since the squatters' actions can't be done freely as it causes harm to the City Council of Mamaland. In conclusion, clearly the plaintiff's interests may harm others under the notion of harm principle, as the plaintiff's decision to not evict the land when clearly the law has stated to do so. Plus, the plaintiff also reacted aggressively when the eviction process was taken as it was supposed to. While my learned friend's opposite client might make it a case that it infringes on the squatters' livelihoods, the law deems it necessary to protect their livelihood well, considering the nature of the land's rights to the City Council of Mamaland, which may also contribute to the benefits of society. And with that, I conclude my submission and I rest my case here. Thank you, Your Honor.
Okay, thank you, Counsel. So, Plaintiff, you have rebuttal?
Yes.
So make it short.
I'd like to raise a question. Is there a reasonable cause to deny the squatters a 3-month extension to look for available housing?
With the court's permission, my name is Jasmina, and I would like to reserve 2 minutes to answer the plaintiff's side of rebuttal. Thank you. So, Young Arif, my learned friends from the defendant's side, submitted 3 submissions. Now I'll prove to the court to why we implore Young Arif to allow that the actions of the City Council of Mamaland State is considered moral and does not violate the principles of freedom. The submission from their side whether or not a 3-month extension of the eviction can be given by the City Council of Mamaland State to the squatters of Taman Enjoy. In this submission, the plaintiff's senior counsel, Ms. Yasmin Soraya, stated that the City Council of Mamaland did not take into consideration the consequences of evicting the squatters from their settlement, such as causing the demolition of their personal property, that is their books and uniforms, as well as the state of them being homeless. Furthermore, since the squatters appealed for a 3-month extension to enable them to find a new place to live, the City Council is actually obligated to refrain them from evicting these squatters until they could do so, and why a 3-month extension of the eviction can't be given to the squatters of Taman Enjoy. But Your Honor, we from the plaintiff's side respectfully disagree with the arguments that, according to Section 7, Sub 2 of the Specific Relief Act 1950, where a specific immovable property has been led under a tenancy and that tenancy is determined or has come to an end, but the occupier continues to remain in occupation of the property or part thereof, the person entitled to the possession of the property shall not enforce his right to recover it against the occupier otherwise than by proceedings in the court. The common law remedy of self-help is well illustrated in the case of Siddiq bin Haji Muhammad and others versus the government of the state of Perak and others, 1992, 1 Malaysian Law Journal 313, where Raja Azlan Shah, CJM, sitting in the federal courts, held that the owner is not obliged to go to the courts to obtain an order of possession. He is entitled, if he so wishes, to take the remedy into his own hands. He can go in himself and turn them out without the aid of the courts of law. He can even use force, so as long as he uses no more force than is reasonably necessary, he will not be then liable either criminally or civilly. The squatters of Taman Enjoy must be aware that the extensions of eviction notices can be given easily, especially when requested at the last minute. As had been done by the squatters, they appealed for a 3-month extension during the protest done by them, even when the 6 months eviction notice had already expired. To add, a grace period must be included in the eviction notice to allow the tenant to vacate the property, settle all overdue rent, and officially hand over in all items included in the property, which had clearly been done by the City Council, which is issuing a 6-month period eviction notice, but no action had been taken from the squatters. Subsequently, Young Arif, we believe that by sending an eviction notice to the squatters is the only step one out of the longer court-backed eviction process. While sending this notice, and often is enough to get a tenant to either shape up or get out, there are a lot of cases that needs to be in check where the City Council will need to escalate it further, since the squatters did not respond to their notice or leave the property within the allotted amount of time. Where number 1, file your eviction with your local courthouse, number 2, gather evidence, and number 3, come to the court hearing to prove your case, and number 4, win a writ of possession and have the squatters removed by the police or other local authorities instead of accepting the appeal for another 3 months extension. With that, I finish my answer for rebuttal. Thank you, Your Honor.
Any more rebuttal?
Okay.
So plaintiff does not provide rebuttal.
That was our rebuttal. That was
That's your question, and then rebuttal provided by defendant. Your own rebuttal. Okay, you want okay, pause okay. Make sure nak ambil masa.
Okay, so Yarif, I would like to raise a question.
Okay.
As the Second Junior Council stated, the Destitute Persons Act 1977 are the core federal state strategies for homelessness for 40 years, in which government officers have the power to conduct raids on destitute persons and detain them in welfare homes. How can you say that the squatters are considered as a destitute person, where according to Oxford Dictionary, destitute means without food, money, or other things necessary for life? Or in other terms, they are extremely poor to the extent that they have no homes. where the squatters can afford building houses on that land and continue living on that land even when they were told to evacuate when the eviction notice was issued. The children had textbooks and uniforms. Furthermore, are able to take examinations that clearly proven that the parents can afford sending their children to school and to pay for and sending their children to school and to get good education, but can't afford to pay a legal land to live. A woman, a single woman that has 6 children, and Arif, most of them are infants or adults that require tons amount of money to support the children's living costs. How can the appellant's team prove that these squatters were not clearly taking advantage and abuse human rights principles to live on the land freely and illegally? Thank you so much.
You make it short, huh? 1 minute.
I got that the defendant questioned the financial status of the plaintiff, claiming that they are capable and not considered poor due to the numerous children and not deserve to be helped. The true meaning of poverty is not based on financial ability but on faith or religious belief. People living in slum often lack education and lack knowledge about family planning and believing that many children can bring the happiness. Therefore, it is not valid to say they are not poor just because they have many children. Do all poor people have to explicitly exhibit that they are all poor? How much longer will the government take action only when the poor come to them and beg for help? It is not that squatters refuse to ask for help. It is because they do not possess necessary information to even ask government for financial aid and convey that they do not possess shelter. If the defendant claims these squatters are capable, why didn't they move out of the slum early when it is a common knowledge that these squatters are inherently unsafe and they live in constant fear that of the land they live on being confiscated at any moment? The government should focus on helping the squatters understand the problem and protect their interests. What does public interest mean for government? Are the squatters not worthy of protecting their interests? If the government continues to focus on development of the country without providing shelter and decent job for poor people, then the law is very cruel and inhuman and should not be obeyed since it causes harm to people and does not reflect pure values in a community. If the community follow this cruel law blindly, it means that the morality and freedom of the community is just a lie and just only a promise made by the government to organize society. The defendant is unreasonable and stereotyped by thinking that the plaintiff is a capable person and does not deserve help just because they have many children. In conclusion, it is the government who should open their eyes and take effective measures to help these poor people have a decent life. Thank you. That's all from me.
Give them some clap.